Hello students, I am Marjina Sultana, an assistant professor from International Law College, Greater Noida. In this video, we are going to discuss schools of Muslim law. There are two main sects of Muslim. One is Sunni and the other is Shia. And the third one that I have mentioned here is Mu'tazilas. Mu'tazilas have no such schools. According to Amir Ali, Mu'tazilas are taken sometimes as an independent sect and sometimes as an early offshoot of the Shia sect. So it was Shia sect. It was closely allied to the Usuli school. So now they must be treated as dead schools that have played its part in history. They have no organized community, no separate body of law. So we are left with only two sects, Sunni and the Shia, and these sects are again divided into a number of schools. So the majority of the Muslims are Sunni, and hence it is presumed that the parties to a suit are Sunnis unless proved otherwise. But Shia law is also the law of the land. In India, Shia law has been applied to Shia since the decision of the Privy Council in Raja Didar Hussain versus Rani Zuhurun Nisa case. So there is two sects, Sunni and Shia, and the Sunni has four school: Hanafi school, Maliki school, Shafi school, and Hanbali school. Shia Shia has is Shia sect is again divided into this Asna Ashariya or Imamiya, Ismailiyas, and Zaydiyas. Asna Ashariya or Imamiya has two schools, Akhbari and Usuli, and Ismailiyas has Khozas and Bohras of Bombay. Okay, so first understand how these two sects of Muslim originated. So initially there was only one. After the death of the Prophet Muhammad, the many competitors came forward to succeed him as a caliphate. So it was more of a political in nature. So it originated concerning the question of imamat or the spiritual leader of Islam. Okay, so the Shias advocated that the office should go by right of appointment and succession, and maintained that the imamat or the caliphate was to be confined to the Prophet's family or his nominees. They believed in the family succession. Shia advocated for the right of appointment and succession, but the Sunnis, on the other hand, upheld the principle of own election by the Jamaat or the universality of the people. So Sunni ultimately chose out their caliph or imam by means of vote. Sunni believed in the vote and you know uh, vote and they didn't believe in they believed in the universality of the people, not restricted to the line of Prophet Muhammad. Shia on the other hand believed in the Prophet's family. So it was in this way the different sects originated. It was more of political, not the religious one, but later the division become more, more intense, more differences came in the future. So in today's videos, we will be discussing the four Sunni school and which is more important from exam point of view also. The Sunni schools of jurisprudence are Hanafi, Maliki, Shafi, and the Hanbali school. These schools were named after the name of the jurist who founded them. So the jurist who developed this system of jurisprudence and after whom these four Sunni schools of Muslim law are named are Imam Abu Hanifa, Malik ibn Anas, Muhammad ash-Shafi, and Ahmad ibn Hanbal. So Hanafi school was named after Imam Abu Hanifa, and the Maliki school was named after Imam Malik ibn Anas, and the Shafi school was named after Muhammad ash-Shafi, and the Hanbali school was named after Ahmad ibn Hanbal. The main principles of law as expounded by these jurists are more or less the same, but there are minor differences among them so far the interpretation of Quran is concerned. So there were not much differences in terms of theoretical issues, but the differences were mostly on its practices, and that too not in core practices. They all agreed upon the core practices. So these these differences developed because of their independent interpretation. The first school in terms of historical emergence is Hanafi school, and as we discussed, it was founded by Imam Abu Hanifa. He was the first jurist who laid the foundation of systematic and scientific study of legal principles. In matters of law, he was generally compared with Justinian, both devoted to law and attempted to solve problems which confronted the society. Imam Abu Hanifa began the codification of Islamic law by constituting a committee of 40 members, which consisting of his learned principals. They were all eminent jurists, consisted of scholars and persons devoted to particular art or professions. In fact, all these members were imams in their own field. And this committee took 22 years to complete its work. And the book, or we can say the collection thus compiled, is known as Kutub Abu Hanifa. It is said that this school solved 5 lakhs legal problems. The school gave prominence to qiyas or analogical deduction but this method, the method adopted by Imam Abu Hanifa in formulating legal principles, were based on Quran and Hadith. So the first source is Quran, next is traditions, but he was very strict and cautious in relating the traditions of the Prophet for forgery. So he preferred qiyas or analogy, which means deduction of an order from a verse of the Quran. So the he followed he adopted the methods of qiyas or analogy by as per the he but per the contents of the verse, reasons of the verse, indication of a verse, or to purpose of a verse. So he preferred to deduce law or rules from the Quran directly by looking at the contents, reason, indication, or purpose of the passage or the verse in the Quran. So he gave prominence to qiyas or analogical deduction, and he was very strict in accepting the traditions because he was suspicious, about accepting any traditions, because when traditions was transferred from one person to another, so there could be uh, you know it could be changed. There was a chance of change modifications in the traditions, because it was narrated by word of mouth and not written down at that time. So he is famous for his principle of istihsan or juristic equity. It is admitted admitted principle of all the Sunnis that if qiyas is inconsistent with Quran or precepts of the Prophet Muhammad, peace be upon him, it will be set aside. So Abu Hanifa has taken a step further and developed this principle of istihsan. According to him, when a deduction based on analogy is not acceptable, either because it is against the broader rules of justice or because it is not in the interest of the public good and it is likely to cause undue inconvenience or hardship to the people to whom it is applied, the jurist is at liberty to reject the rule and to adopt one which is more suitable. That is called station or juristic equity. And it is, as already said, it is according to the Quran or traditions. And this istihsan, principle of istihsan, is the unique one which was developed by the Hanifi school. So he believed, the basic aim of Islamic legislation is to do justice with the individual as well as society, and in which lies the welfare of the humanity. So this principle of istihsan embodies the same principle, that is the welfare of the society. In fact, this principle of istihsan, this is less liable to error comparing to the analogy or qiyas. So first is he gave preference. First is Quran, then traditions, then qiyas. But if qiyas is you know not in the interest of the public, then he used istihsan or juristic equity. For example, this theory istihsan means that by using this principle of principle, the theory of law is modified in its application to actual facts. So when the law is deduced by using the qiyas or analogy, when it is against the public interest, he used the principle of istihsan, so to modify the theory in its application to actual facts. So it was to provide elasticity and adaptability and to in the practical use. So let's take an example. This illustration will make it easier to understand his way of establishing his methods in establishing the legal doctrine. For example, in Islam, a contract of the nature of sale for sale, uh, according to Islam, to make a sale valid, it requires that the subject matter must be in existence at the time of the contract. So, arguing analogically, a contract with a manufacturer or artisan that he is to supply goods of a particular description for a specified price would be invalid, because an in Islam, the subject matter must be in existence at the time of the contract. So, analogically, if we try to deduce law, then if there is no subject matter, it would be invalid. But by using the principle of istihsan, this principle intervenes and establishes the legality of such a transaction on the ground of necessity based on the universal practice of mankind, and, and it is not forbidden by the Holy Quran. If anything, maybe by using the principle of istihsan or the principle of qiyas, if it goes against the Quran and the traditions, it will not be accepted. It will be set aside. But if something is, if by using the istihsan, it is, uh, it is providing some practical importance for the good of the people, and it is not against the Quran, it is not forbidden by the Quran, it was accepted. Maliki school is also known as Madini school because this Maliki school commenced its life from the Medina city of learning, and the first school, that is Hanafi school, oh, commenced from the Kufa, that is the famous city of learning. And this Hanafi school was in Iraq, and the Maliki school was in Medina city. The founder of the Maliki school, that is Imam Malik ibn Anas, who was the founder of the Maliki school, was a great traditionist as well as great jurist. He was also a working judge, so he occupied in meeting real cases day to day. One of his greatest contribution was Muwatta. Muwatta is a small collection of hadith traditions limited only to the practices of the people of Medina, but it was considered one of the most authoritative. The people looked up to uh, you know to him as a this book as the highest authority in hadith. The methods of formulating legal principles, the methods adopted by the Imam Malik was uh, that his first source was essentially the Holy Quran, and then came the traditions of the Prophet, peace be upon him. Among the traditions of the Prophet, peace be upon him, he preferred the traditions which were collected and narrated by the traditionists of Medina. After the traditions, the sources of law are ijma and tamul, or usages of the Medina, as he considered that the practices of people of Medina exhibited the true spirit of Islam. He relied much on the traditions of the Medina, people in Medina. In the first school, Hanafi school, they gave more prominence to the qiyas, and in the second school, the emphasis is on the traditions of the Medina. So, this Maliki school gave much weight to the traditions and the usages and practices of Medina. So, Imam Malik learned more upon the traditions and the usages of Medina. He attached, because he had he gave much importance to the traditions of Medina, relying on the presumption that they must have been transmitted from the times of the Prophet, peace be upon him. And the Medina was the place where the Prophet spent his last years, and the people, that is Medinis, people of Medina, were his companions and devotees. So they had, people of Medina had the opportunity to study the Prophet, peace be upon him, very closely. So he believed that the traditions of Medina reflected the Islamic spirit in their deeds and the practices. So what was his contribution? His contribution was that he developed a system which interpreted Islamic legal principle in true spirit of Holy Quran, traditions, customary law, and the practices of Medina. In cases where neither Medina traditions of Medina nor Medina Ijma existed, he laid down the law independently. In other words, he exercised Ray. Ray means opinion. Okay, so he relied less on qiyas and the istisla. In the first school, Hanafi school, exercised more opinion, and but in the second school, Maliki school, they relied more on the traditions that were prevalent in the Medina. Imam Shafi was one of the greatest jurists in the history of Islamic jurisprudence. He was the founder of the science of usul. He wrote Risala, that was a treatise on the principles of Islamic jurisprudence, which deals elaborately the sources and the principles of law. Imam Shafi's greatness lies in that he studied Sharia keenly and himself wrote many books on Islamic jurisprudence. Undoubtedly, he is regarded as the founder of the Usul al-Fiqh. The methods of formulating legal principles adopted by Imam Shafi was that he based his doctrines on Holy Quran. He says that Quran is the basis of legal knowledge. And next, he's traced on the Prophet's Sunnah next to the Quran. So he was known as the upholder of traditions and got the title of Nasirus Sunnah. But he adopted the middle course in following traditions, that is between the Imam Abu Hanifa, who learned more on passages in the Quran and his own deductive opinion, and the Imam Malik, who learned more on traditions, usages, and practice of Medina. Means that the first Imam who relied more on the deductive opinion, and the second one, Imam Malik, on the traditions, but he adopted the middle part. And the third sources was ijma. He even universalized the institution of ijma. He was a strong supporter of the doctrine of ijma. He accepted the ijma of all the people of all the ages. They're not limited to the certain to the particular period or to the few scholars. So he universalized the institution of ijma. He adopted more liberal approach in terms of ijma, and the fourth doctrine on which Shafi based was his doctrine was qiyas, or analogical deduction. After ijma, he adopted qiyas, and Imam Shafi was the first who laid down regular rules for qiyas, or analogical deduction. So according to him, Imam Shafi says that the method of reasoning based on certain indications leading to the correct decision is ijtihad. So according to him, qiyas is a variety of ijtihad, which Shafi, the Shafi school approved, provided that it is not against the Quran. There is a we should have a relevant text in the Quran on tradition to which analogy could be applied. So Imam Shafi adopted the middle course and gave a clear and balanced theory of law. He was noted for his balanced judgment and moderation views. See, he gave regular rules for analogy and let down the, in terms of ijtima, his contribution was that he he developed rules, and for the first time he started systematic legal reasoning and surpassed from other jurists of his age in systematic methodology. So he was a master of fiqh as well as a great scholar of traditionist. In the case of uh, Imam Malik, that is the second school, he adopted all the traditions. His focus was on the general practices, but Imam Shafi, he did not just accepted all the traditions. He attest on somebody. Uh, he relied on specific traditions, not all the traditions, but those specific traditions which is attested by someone as coming from the prophet. He wanted clear proof because in his time this this it was developed into a science. Okay, so the hadith, the tradition was readily available, but in the time of the Imam Hanifa or Imam Malik the second, there was very uh, less traditions. I mean, it was not written down. But during the time of Imam Shafi, it was, uh, the science. He felt like he was dealing with a exact science. So he focused on those traditions which could be related to the prophet. There was should be a clear report, clear narration, clear chain of narrations which could be attested as coming from the prophet, which could be traced back to the prophet. Imam Abu Abdullah Ahmad ibn Muhammad Hanbal, commonly known as Ibn Hanbal, was the founder of the Hanbali school of Islamic jurisprudence. He was a great traditionist as well as jurist, but undoubtedly he was more traditionist than a jurist. His method of formulating legal principle was simple and was the same of Ashab Hadith. So he sought his answers of legal questions from Holy Quran, and next source was Hadith. He also accepted ijma as a source of law, but he made little use of the ijma due to the dependence on hadith. The fourth source of law that he allowed was qiyas, but he uh, allowed qiyas merely in sheer necessities. He always tried to derive law from the traditional sources. So his method of formulating legal doctrine was Ashabe Hadith. So he made extensive use of traditions, and his inclination was towards traditional sources of law and to avoid ray, that is opinion, which he considers as a very weak source of law, and there is always possibility of error. So he was a great lover of traditions and himself collected traditions. And so his famous work, Musnad Ahmed, was the collection of traditions. So he based his fiqh on traditional sources. So Imam Ahmad, uh, he also had, his it has been already mentioned that Imam Hanbal's method of formulating legal doctrine was Ashabe Hadith. So we find very few books on principles of fiqh in Hanbalite legal literature, whereas there are numerous work on Hadith. And his Hadith, his book Musnad Ahmad, it contains nearly 30,000 Hadith. So we can see that there is how differences arose between these schools of Muslim law, that during the time of the first school, by the Hanafi school, they used more opinion, they exercised more opinion and preferred to go with something which is clearly derived from the Quran, and they were suspicious about accepting uh, traditions as it was not developed in the during the time of the Imam Abu Hanifa. And in during the time of second school, Imam Malik, he was already in Medina, so he saw that there are people following the tradition. He was in Medina, and he believed that the practice or the traditions followed there in Medina, the way of practices and everything was, transmitted from the Prophet Muhammad. So he relied on that. The uh, the, the traditions of the practices followed by the Medinis were accepted. That's it for Imam Malik. And during the time of Imam Shafi, the science of collection of the traditions were more advanced, it was more developed. He had the confidence to rely on the traditions because you know when it was already graded as authentic or weak hadith. So he also followed traditions, but it was different from the Imam Malik, the second school. The second school, that is Maliki school, adopted general practices, but in the third school, the Shafi school, they emphasized on the specific reports. They followed the tradition, uh, uh, but not just the general practice. Not only it was not sufficient for the Shafi school that the mass numbers of people or large number of people in the Medina were following a particular tradition, but he wanted a specific reports that could be tested as coming from the Prophet Muhammad. So first school exercise opinion more on analogy, second on general practice, the third school specific reports, and the last school, Hanbali school, they adopted literal application of, okay, literal application, because during that time the it was more developed. The he himself collected 30,000 traditions, which is, there was a huge difference during the time of Imam Malik, who started applying tradition. During his time, he had only 500 traditions. Imam Malik had 500 traditions. The founder of second school, and the founder of the fourth school, Imam Hanbali, had 30,000 traditions. So he had already armed with a lot of traditions. So there was a less scope for, less need for exercising opinion. So there was no need to think, because he had already enough instructions on every matter from A to Z. So there was less opinion and more on the more of literal application of the traditions. So it was all about the schools of Muslim law. Thank you.